Welcome to the Slingshot. Laurel Kilgour is our special guest today. Laurel is a research manager at the American Economic Liberties Project, AELP. She frequently writes and speaks about high-profile cases like the one we are going to talk about today. And prior to joining AELP, Laurel was of counsel to Kumar Mole and an attorney at Goodwin Procter. Hi there, Laurel. How's everything?
Hey, great to be here.
Now, we're going to be discussing remedies in the Google search case today. And Laurel attended the remedies phase of the Google trial, yes, and covered that extensively on Twitter. We're going to organize our discussion today into three topics. The first is objectives in remedy design. The second is the DOJ's Chrome divestiture proposal. And the third topic will be the DOJ's data sharing and syndication proposal. Of course, the DOJ is proposing lots of other things, but we're limited in our time. And one, of course, is they're seeking injunctive relief relating to Google's exclusionary distribution restrictions. But I think this one is less controversial, so we're gonna leave that one to the side. A quick disclosure from me: I'm the plaintiff's expert in two ongoing matters involving Google: the Google Play Store UK case on behalf of consumers, and the Google Ad Tech case on behalf of advertisers. With that, I want to introduce Darren, my partner in crime, who's joining me as usual. Darren is a law professor at University of Houston, teaches antitrust law, and I think has a class right now called Capitalism and Oligarchy. Is that right, Darren?
Yeah, for now. We'll see how it happens after the state legislature comes by. If you do hear crashing in the background, that is either thunder from heavy tropical storms or the state legislature, or who knows, it could be Iran retaliating. We're not sure yet.
All right. Okay, well, let's just move right into the first topic, if that's okay, Laurel. This is concerning objectives in remedy design. The DOJ has to point to Microsoft 3 for guidance in remedy design in a monopolization case. And it was a four-pronged test, and I'm looking at some of them are easy, some of them seem hard. So two of those objectives are challenging in the sense they seem harder than merely enjoining the anti-competitive conduct. These hard ones are: one, denying the defendant the fruits of its illegal behavior, and two, restoring competition. Now, setting aside the challenges, Laurel, my question for you: are these objectives controversial in any way? Or are we just debating how best to achieve these objectives?
So Google grudgingly acknowledges that those words exist in precedent, including the Microsoft case. And it would be really hard to say that those are not, actual objectives from precedent, because they do come from Supreme Court precedent as well as the Microsoft case. And in particular, so denying fruits of illegal conduct is a really old concept in equity that is not even unique to antitrust cases, right? So if you rob a bank or if you embezzle money from your employer, you don't get to keep that money. You have to give it back. And so there were findings in this case about what those illegal fruits from the illegal conduct were. And Google's argument is more that the DOJ didn't adequately identify what those fruits were. So Google is making more of an argument saying that there was insufficient proof. And similar for prying open the market to competition, that is an antitrust specific remedy. It comes from a bunch of Supreme Court cases like International Salt, and Ford has been around for a really long time. Google is also just kind of trying to say that there isn't enough proof in this case.
So I always give the example in one of my in my antitrust class of when you have to when you deny the defendant the fruit of its illegal behavior, that's just giving it back. So if I have a probability of not getting detected, then it always pays to rob. So of course, in private plaintiffs, traditionally have these treble damages. But they don't really get treble damages, as the empirics kind of bear out. So it seems to me like if we're going to restore competition, then you have to do something beyond just those things. I think back to the Colbert Report AT&T discussion. I don't know if you remember this, where he walks through the AT&T breakup and then he shows the reacquisitions that lead to AT&T eventually coming back to full power. And so I'm trying to think of ways that would bar Google from reacquiring what it loses. And it seems to me it would have to be a bar on certain future acquisitions and to hold any subsequent acquisitions to a higher standard. So even to me, structural remedies have to have some conduct remedies going forward to be fully implemented. Do you agree with that? Do you disagree, or is there's no way in hell this is happening?
Well, I think I would categorize those kind of remedies on what types of future acquisitions and investment can be made as ex ante structural, structural remedies. Maybe there's a matter of semantics about whether they are behavioral or structural, but, my first instinct is to say that that's structural. And I totally agree that there should be, some clear guardrails about what Google can acquire or invest in. And there originally was, in the DOJ's first round of proposal, there was a much stricter kind of bright line rules about Google can't make certain types of acquisitions and investments relating to search and AI that, uses search as a grounding in some way. And then after the change of administrations, that was relaxed a bit so that there was no longer any kind of absolute ban. Instead, it is more like notification regime, a bit like the HSR requirements, except that it would apply to below the HSR threshold. It wouldn't just be for major acquisitions. It would be even for things like startups. But again, it would only be noticed. So it's possible that, the DOJ could go easy on Google. So I do think there has to be more. And I think another thing that is not entirely clear to me from the remedy proposal. So one thing that is clear is that Google cannot build a new competing browser for the duration of the remedy period, which is 10 years. It's less clear to me whether Google could theoretically buy back Chrome if the Chrome browser is sold off after 10 years. That's a little bit less clear to me. I think that language should be made more clear that this is sort of an indefinite thing. And that was what happened with the Paramount decrees. That was a, complete divestiture of different parts of sort of the movie production chain between theaters and producers. And that ended up being, there was no, end point to that. It was just sort of an ongoing thing, and it lasted for 70 years until, the 2010s or something, when the DOJ was suddenly like, oh, the market has changed and magic technology changes and streaming. And, then they lifted that decree, and that has, many people would say that has not turned out very well. So in that case, it's like, well, even 70 years wasn't long enough. It should have been longer than that. So I think it would be concerning to leave open this possibility that Google could reacquire Chrome, or if the Android divestiture is triggered, it's also not clear how long, could Google eventually reacquire Android. So I think I would want to see a lot longer than that, and something that is more like, the burden is on Google to show that there should be any reason to reacquire it, and maybe certain bright line thresholds.
So before we get into the divestiture and other specifics of this remedy, I know there's one fight going on over objectives, and you seem to suggest, Laurel, that they're not really so much fighting about what the objectives are for Microsoft 3, right? But there is another fight, I think, relating to causation. I want you to help us understand that one too. This is my lay economic reading of what the fight was about. But it seems that the DOJ is arguing that the challenge conduct allowed Google to maintain its monopoly. And that causal connection justifies the DOJ's remedies. That's what I understand their causation argument to be. Google seems to be offering up a different causation standard. It's called but-for causation. Mm-hmm. And I'm wondering from you if you could help us understand what Google's trying to say, and if the case law supports Google's claim that the conduct must be shown to have caused the monopoly altogether. I wonder if that's what they mean by but-for causation. So, and who's right here finally?
Not Google. So, well, let me start with, so my colleagues filed an amicus brief in this case, and we said that so there's this language from the Microsoft opinion that says there needs to be some kind of significant causal connection. And that's something that can be read as dicta. And there's an argument that really what you need to show is just that the relief is a reasonable method of eliminating the consequences of the illegal conduct. So, the significant causal connection language, which by the way just comes from a Hovenkamp treatise, that it's not clear. There doesn't seem to be, it seems to be a weird interpretation of some Supreme Court opinion, but I don't know what that is. And when you actually look at the Supreme Court opinions from that era, it's really unclear where that exactly is coming from. Because the Supreme Court opinions are very strong on remedies. Again, like judges have broad, wide discretion and equity to make something that essentially it's about solving the problem. So it's not, the Supreme Court has said over and over again, you're not limited to just the paths that were traveled. You also have to address other things that could happen. You have to pry open the market to competition. That's the language from the Supreme Court. You have to sort of divest those illicit fruits from the anti-competitive conduct. So, the actual Supreme Court precedent is very clear that remedies are very broad. That's what happened in those older cases when there were, big breakups and divestitures. So it's hard to get to, and including in product lines that weren't super relevant. Or to the actual monopoly power, because even in like Standard Oil, you had a breakup into dozens of pieces, which were not just sort of like oil companies, but random like tanker companies and like things that didn't have to do with the core monopoly, but it was like breaking off all of it, right? And by contrast, this in that light, like this Google set of remedies is much milder than that. You're nowhere close to breaking up the entirety of Google's empire. But also in terms of this significant causal connection language, like the DOJ does suggest that there is something of a heightened causal connection that is required, but it says that the judge's findings met what that standard is, because the judge had findings that the Google's conduct foreclosed a substantial portion of the relevant markets, that impaired rivals' opportunities to compete. It denied rivals access to user queries or scale that was needed to compete. It reduced the incentive to invest and innovate in search, and required rivals to distribute their general search engines through less efficient means. So there were a variety of findings, and the DOJ is saying those findings meet whatever that significant causal connection standard is in Microsoft. Google is taking that language a step further and trying to say that significant causal connection means but for, that you have to prove that Google, what Google's market share would have been but for the monopoly maintenance conduct. And here Google is making a distinction between saying, look, the judge said that we acquired our monopoly totally legally through innovation. Like we were not in the wrong to form our monopoly in the first place. What we were found guilty of was maintaining the monopoly through this sort of corporate bribery of Apple, paying them, tens of billions of dollars a year to make Google search the default search engine, also paying off a whole bunch of device makers, Mozilla, things like that. So that's sort of what the accusation is in terms of that Google was found guilty of monopoly maintenance. And Google is saying, well, okay, at the period that we allegedly started this, or found to have started this monopoly maintenance, we already had an 80% market share in search. So, and you need to tell us, what above that, now they're up to like 90%, what above that was because of our anti-competitive conduct. And the DOJ is saying that's, an impossible task to recreate that but-for world of, okay, if Google had not been bribing all of these distribution channels, what would have happened? You can't prove that with any kind of precision, right? So that's sort of the argument there. And that was also something that the Microsoft court itself said, that reconstructing a but-for world is something that the judge and the parties really can't do. So Google is really trying to strain this Microsoft language, far beyond it can reasonably be interpreted. And they're also trying to say, this significant causal connection language was only used by the court in the context of divestitures, of breakups. Google is trying to say that actually, this significant causal connection standard, which it says is a but-for standard, Google is saying that applies to anything that's other than just injunctive relief of stop doing this corporate bribery and stop having these contractual terms. So Google's not only using this really heightened standard, it's saying this heightened standard applies to almost every remedy against it. So including like the data syndication remedy that the DOJ is seeking, the data sharing remedies, all those kinds of things. So Google is really going out on a limb in terms of how extreme the types of arguments it is making about the standard here.
You've just convinced me I should start a different line of work where I go advise schoolyard bullies. And I tell the schoolyard bullies their argument should be, look, some kids are going to naturally be afraid of me because I'm really big and strong. And, and you have to determine how much more afraid they are of me after I hit them.
That is excellent. That might be better. I was trying to think through more kind of like sports ball analogies. Like, for example, so if an illegal monopoly would be equivalent to, okay, you took steroids. So none of that was like, very little of that was like your actual natural skill. But you could also have someone who, they don't take steroids, but they do Deflategate, like Tom Brady allegedly did, or, they bribe the ref, something like that. In both of those situations, that doesn't mean you have to have mutually exclusive remedies for those different things. In both cases, the remedy, even if you say that this is not about punishment, this is about maintaining the integrity of the sport, which is like actually one of the terms in, NFL, kind of arbitration, how they resolve whether their rules were broken or not, like preserving the integrity of their sport. In both cases might mean that suspension for, you don't get to go to the Super Bowl or the next game or the next level or whatever it is. You could have the same remedy be appropriate for two very different types of conduct, right?
Yeah. Speaking of integration of remedies, the movement for an open web wanted greater coordination in terms of picking apart Google, and similarly, your partner Matt's in crime at AELP, Matt Stoller, just wrote in big that the DOJ remedies were too timid, in part because the U.S. courts have largely been fed neoliberal dogma that the long-term efficacy of divestiture is rarely certain, and you do see this theme throughout about the structural remedies being bad, most notably in our monopoly treatise. Why does antitrust only have a monopoly treatise? That's odd. The Hoven-Camporita treatise. Do you agree that about having greater integration between the remedies and DOJ's being far too timid?
I mean, I think he makes a really good point that, currently judges, because they haven't done this in so long, and because there is this sort of, during the neoliberal era, like certain assumptions just became normalized and baked in, even those were, are very radical changes from if you apply actually, textualism to antitrust as if it were an area of law rather than some kind of weird, stepchild of economics. I think that, currently judges are more afraid of being overturned for being too bold. But, Matt made the point that during, the mid 20th century, when this stuff was more common and they were applying the law to the facts, that judges were more concerned about getting overturned for being, too timid. And the Supreme Court actually did that. When a district court going back to review whether a remedy was effective and do I even have the jurisdiction to fix things after it turns out the remedy was not effective, the Supreme Court basically said, yes, of course you should fix this. You need to go back and fix the mistake that you made by being way too lenient on this person who violated the law. You had to go back and fix that, and you have to go back and fix that, very strongly suggested through divestiture, which is then what happened. So I think that point is important. I think that, if we had been in a different era, we would be thinking about this case in a very different way. I mean, you could have approached this case by saying, okay, well, Google should have to sell off search, right? It's this big conglomerate. What would happen if we sold off search? I think in a different era, that might have been, a starting point, at least a negotiating starting point, and that could have been the result. Or because you can't break search in half because it's more like platforms, you could do this more like the mid-century remedies where there is some kind of, non-exclusive licensing on FRAND terms, right? Like there could be some kind of licensing out of the technology so that people could grow their own search. And there are elements of that here, but it's not as bold as it probably would have been in the middle of the 20th century. And I think this case also kind of highlights the difficulties with case-by-case adjudication in an era where there's been decades of non-enforcement, under-enforcement, because I think if Google's monopolies, and it has now been found a monopolist in 3 different cases and counting, right, in 3 different markets, I think if those monopolies had been caught early as they were emerging, like it would be much simpler to figure out what the remedies should be. But its empire is so integrated and so interlocked that judges are now, having to face this challenge, as you raised, that the movement for open web point that they made was that, all these things are going to interact with each other in some way. So the search remedy and the ad tech remedy, and even the remedy in the Epic case, like judges are going to have to think about how all of these things fit together. At least the technical committees are going to have to think about how all of these things fit together. And that was actually one of the challenges in implementing the Microsoft case, was that there were some restrictions on communication, or it wasn't clear how technical committees in Europe and in the United States could communicate with each other. And having those lines of communication is open is very important, especially when you have a recidivist who has a proclivity for doing kind of malicious compliance.
Laurel, I want to pick up just on this point again, in like where divestiture remedies got a bad rap. Mm-hmm. And Matt Stoller in his blog said that the Microsoft court pointed to Hovenkamp's treatise as the citation for the bad rap, something about long-term efficacy, questionable long-term efficacy or something like that. And I tweeted this, and Herb replied to me, and he said, actually, you don't have to go, they didn't have to just cite to me, they could have cited to Crandall. Now, I'm familiar a bit with the Crandall Winston work, suggesting that some of the outcomes that were achieved via lighter touch remedies in the U.S., like unbundling for AT&T, realized just as low long distance rates as those achieved in Canada through divestiture. And I know that Jonathan Baker did a reply to that, but this is ancient history. This fight unfolded in like the late 90s, early aughts. If you were going to instruct an antitrust student of where to go, try to get up to speed on are divestitures bad, where would you send them?
Well, I think the first paper I would refer them to is Rory Van Loo's paper, In Defense of Breakups, Administering a Radical Remedy. That's from 2020. So I hope that meets your criteria, being sufficiently recent. And that does several things. So it does look back at several of, various breakups in history, and notes that, even like the AT&T breakup, which took a really long time, was followed by innovation and lower prices. And scholars may, differ on some aspects of whether it was ultimately a success, but like they don't dispute, most people who are serious don't dispute that there was a whole bunch of innovation. Cell phones, wireless cell phones was something that came out of the AT&T breakup, that type of innovation. And that makes the point that even though, there were maybe some criticisms of the way that the judge administered the case with how long it took, but even lengthy and messy breakups can still be followed by innovation and intense competition. So maybe we shouldn't be as afraid of them. The other, sort of major point that Rory Van Loo makes is looking at that there are plenty of private sector examples of companies breaking themselves up. And that's not just small divestitures. That's not just like non-tech companies. There are a bunch of reversed acquisitions, like between PayPal and eBay, AOL and Time Warner. So there are all of these, professionals out there and methods out there of doing breakups. And the DOJ hired had as retained as an expert David Locala, who was head of M&A at, I don't know, Citibank, or one of the really, impressive ones. And he was like, yeah, this is how the process works. Like you have a buyer, and then you have sort of different stages of how, this divestiture would work. And this is normal within the private world. And one of the other major examples was Hewlett Packard, which is a, reasonably high-tech company. It was an integrated company, one unitary thing. It split itself right in half. And it did that even though the cost was like $1.8 billion in terms of making this actually split apart actually happen. It took years to complete. There's a certain amount of disruption that happens to company operations by doing that. But HP decided that this was still a good idea. And lo and behold, they, created two separate yet profitable companies, and it turned out okay. So there's no particular reason for courts to be afraid of divestitures, and there aren't really, every time, monopolists will, say the sky is falling, that there's going to be industrial apocalypse, and there just aren't really examples of like that. There are examples of breakups that took a long time to complete, or that were not, as thorough as they could have been. But there's nothing that suggests that you're going to, damage an industry, destroy an industry, destroy the economy. Like there just aren't examples like that. And more often there are examples of positive innovation and positive results from breakups.
Well, when you compare the other side, so we always look, all right, so we're going to do these intensive discussions of the 3 whole data points we have in the 40 years here of structural breakups. But we have a history of conduct remedies. For our newer members of life, just want to say the history of Microsoft is that Judge Jackson failed to hold a hearing on remedy and then talked to a reporter, and then the case got shifted to Collar-Catelli, who in the remedy order cited to 9/11. And there happened to be a change of administration. And so Collar-Catelli pressured settlement. Charles James was happy to oblige. If you want to read all about this, I highly recommend Harry First and Andy Gavel's book on Microsoft. So, all right, all that discussion, okay, the structural remedy was foreclosed because of that. And so we have a conduct remedy. And I'm sure because we're trying to keep as unbiased as possible in terms of economics literature, there are lots of hefty studies about conduct remedies throughout time that have compared that that remedy to other perhaps more draconian remedies, right?
Yeah, well, so the one that comes to mind for me is Tommaso Valetti and John Quacca wrote this paper about unscrambling the eggs, and I don't remember to what extent they looked at the U.S., but definitely they had a whole bunch of examples from Europe, where the European approach to big tech, for a while they were viewed as being first movers and ahead of the US in actually doing something about big tech monopolies. But often what they did was just a bunch of series of escalating fines, which was not sufficient to solve any of the market problems and just wasted time. So, extended monopolies for decades and didn't actually solve problems. So, there is that sort of track record. Also in the US, we have the track record of the Bush and Obama era consent decrees when they waved through mergers by just saying, we'll be a deal maker and make you divest some tiny little thing and, let your merger go through. And so those types of consent decrees, when they failed, it was because they were thinking too small and they weren't creating a real competitor. So that was something that haunted the Kroger-Albertsons merger, because Albertsons had previously acquired Safeway, and in conjunction with that, there was a divestiture, but it was too small to a buyer that couldn't absorb it. And that failed because it was too small. So there is a risk of going too small with divestitures, but I don't think we've ever have any cases where you went too big with a divestiture. They're again, Standard Oil – this huge empire split into 34 different pieces.
So, speaking of ancient history, I just want to stick on this for a bit. The DOJ, if you look at their post-trial brief, is citing two cases, if I get these right. United Shoe, which was like it was resolved in the 60s. That's even before I was born. And then the AT&T case resolved in the 80s as examples of successful divestitures. And I don't even know if this is necessary, but do you think there's a plausible nexus or story that can link up the kind of monopoly that Google was found to have had and those of AT&T and United Shoe?
Yeah, so I mean, I think United Shoe is a really great cautionary tale about doing too little. So there was a consent decree. This was a shoe machinery market that was monopolized, and that was a unitary company. So again, it was not created through project. It was not a product of a whole bunch of mergers. One unitary company. And initially there were just some kind of milder remedies like conduct remedies. And then the DOJ went back to the district court 10 years later being like, this is not reopened competition. We need to do something about that. And the district court was actually kind of skeptical about it and whether it actually had power to do that. It said that the object of the decree was not to restore so-called workable competition, but to just move towards establishing it, which sounds a lot like what Google is saying, and that the 1953 decree has operated in the manner and with the effect intended. It has put in motion forces which, aided by new technology, have eroded United's power and already dissipated much of the effect of United's monopolization. This went all the way up to the Supreme Court, and the Supreme Court was like, no, you haven't done enough. The district court does actually have the power to address this and should address this. And the court said that if the decree had not extirpated practices that have caused or may hereafter cause monopolization, additional relief was necessary. And it was, in fact, the court's duty to order that if the remedy had not worked after this period of 10 years. And then on remand, the district court ordered a divestiture of shoe machine assets. So, there is a real risk that if you don't have a sufficient decree in the first place, that you have to go back and order that later. But in the meantime, there have been all these additional fruits of monopolization. And in this case, there's sort of the extra twist of, we're at an inflection point with AI. So there is kind of this there is this history with an antitrust that, remedies have been very important at inflection points like IBM, antitrust case led to sort of the birth of the software industry. And we know that we're at this inflection point with AI, and you don't get to rerun that if you have too mild of a remedy in 10 years from now, if Google has also locked up AI, like there's some degree of competition that could be killed forever. AT&T, similarly, there had been antitrust cases against AT&T or scrutiny for decades. The FCC tried behavioral remedies for decades and they didn't work. So there was eventually a breakup. And scholars have found that breakup led to an increase in patenting in the telecom sector by 19% after the breakup. So it led to a lot of innovation, again, including cellular phones. And another similarity between AT&T and the Google case is that they both made arguments about national security. AT&T said that, and this is common with many monopolists, said that breaking it up would be a harm to national security. The difference is that AT&T actually got the Defense Department to weigh in against the breakup. Google doesn't even have that. So the Department of Justice is like, no, the US federal government gets to decide what is a risk to national security. Google doesn't get to decide that. And Google doesn't even have, the Defense Department weighing in on its favor. So
I want to go back to my schoolyard bully analogy. So the bad parenting of a remedy is that if the bully hits a kid and you say, don't hit the kid again, then the bully goes in and foot sweeps the kid or shoves
Right.
the kid, right?
Mhm.
And you're suggesting perhaps the next thing that may not be included to a sufficient degree is using AI agents to the detriment of smaller players.
Mhm.
Right. So that is there a way to craft the remedy to be a better parent or a better teacher so that the bully doesn't go in and shove the kid again with AI after
Right.
punching it?
Right. Well, so there was even in the liability phase, AI was kind of all over the place. There were recognitions that the future of AI is at stake, and early in the remedies phase, although even as Google was sort of making noise in the press that like, oh, AI is totally relevant here. At the very first discovery conference they went to, they caved immediately and were like, yes, we're going to give AI discovery. And then during the remedies phase hearing, the DOJ brought in a lot of market participants like OpenAI, like Perplexity, all these other market participants and experts to talk about, how search relates to AI. And a lot of these LLM AI products use search to ground their AI offerings. And, there is some emerging dimension of competition. The judge has been somewhat, it sounded like the judge is sort of struggling with the legal question of do they have to be in the same market, the remedies. Like, so AI was not part of the formal market of general search market so he's trying to figure out what is the nexus that needs to be required, and maybe this is about focusing on sort of the mechanism of the anti-competitive practice, so that this pattern of behavior around distribution of technologies, and as long as the AI relates to search in some way, maybe that's how you draw the line. So it'll be interesting. He's thinking very clearly about how to draw the scope of what sort of can be affected by the remedy. Like, it can't be something that is, totally unrelated to search in any way. Like, there has to be some kind of nexus to search. It seems to be his thinking about this. But I think a lot of that can be, distribution through browsers and on devices. Focusing on that conduct and that pattern, I think it is helpful to make sure that Google doesn't get a monopoly on AI.
So I wanted to shift to the final topic, if that's okay. It's the data sharing and syndication rules. And I have to acknowledge that when I first heard about them, I was a bit skeptical. But I've now read, the DOJ's briefs, and I'm going to try to pare back some of their arguments, and I want you to weigh in. But it seems to me what they're arguing is that even if Google's rivals were to suddenly gain access to these formerly foreclosed distribution channels, that Google would be able to still dominate because it has such a head start, and some of that head start can be attributed to their to some artificial advantage they achieved through the challenge conduct. And they talk about economies of scale, and they did it, I felt, in a convincing way. They talk about economies of scale in several dimensions, including in both search and ranking algorithms, as well as in ads algorithms for selecting higher quality, more relevant ads to match search queries. So I'm just wondering, Laurel, were you as smitten as I was on this, or do you think that that Google has a good argument for pushing back on some of the data sharing remedies?
Well, I think all of these remedies are meant to work together, and they're about lowering barriers to entry. And it's not about that there's going to be data sharing forever. It's about what is necessary to jumpstart the market, jumpstart competition in the general search market, and in the ad market as well. So data sharing is sort of meant to be a longer term of these types of remedies. So it's about like the user interaction data, but also sort of local content that people are paid to add, or what Google employees add to to search results. And it's about helping companies build their own ranking systems in the longer term. And you just realistically need data in order to do that, in order to improve quality, and also potentially use that data to help build new features, including AI-related features, new innovations. So that's sort of the thought behind the data sharing remedy.
Yeah, and this is something Darren's already raised, but the adversaries or the detractors of divestiture seem to suggest that conduct remedies are easy and wonderful, but conduct remedies require monitoring and enforcement. And I was reading about this one, and I started to get a little uneasy. And maybe you can help me pass this queasiness when the DOJ starts talking about the terms of access. And so what they say here is that search syndication would be offered at quote unquote marginal costs, and text ad syndication would be available quote on terms no worse than those offered to current or future ads syndicators. end quote. I'm an economist, but I just in reading that, I was having a hard time interpreting what the heck that meant. And I recall also that we got into these lengthy battles in the unbundling wars. I'm dating myself, after the Telecom Act passed, as to what was necessary and what the right price should be, and all these different metrics of total elemental, long run incremental costs. Do you think that these are definitions that are enforceable on a going forward basis, or do you think that this is going to trip up this conduct remedy like other conduct remedies have been tripped up in the past?
So I think, I don't know how DOJ arrived at that language. Like maybe it's possible that there are commercial agreements out there that, they've looked at and they said that based on Google's existing, some of the, evidence from trial is like, under seal or, not available to everyone. So I don't know what commercial terms in particular they were looking at, but, maybe there was a contract that they looked at and they said, this is clear enough. Like, if this is what Google is already doing, maybe market participants, said that this is something that they can live with. So I don't know, that's speculation in terms of how they arrived at it. I do, I totally agree that behavioral remedies can be much more difficult to enforce, and it really depends on, I think, observability. Like, is what's going on, a black box? Like, there are examples with big tech where, like, if you're, if what you do is an opaque algorithm, like, and you change the opaque algorithm, and you don't have researchers have access to, kind of reverse engineer what the algorithm is doing, then yeah, it's really hard for, enforcers or regulators to figure out what, has there been an abuse and how do you actually monitor that? So, I think it depends on how it's implemented. And I think a lot of details have been, kind of kicked to what is the technical committee going to decide? And, each of the parties will nominate someone to the technical committee, like they did on Microsoft to sort out a lot of things. So, it's hard for me to tell whether it's crafted in a way that, will be easy to monitor or not. But there will be a technical committee the way there was a technical committee in Microsoft. And the syndication remedy is one that is somewhat shorter term. So it's more about this idea of kickstarting competition that and the remedy proposal says that only qualified competitors who are basically planning to have serious plans, business plans, investment plans to build their own search engines, they're the only ones who get this syndication. So they have to, have a certain level of sophistication, and that they will get access to these high quality results as sort of a bridge to doing this, on their own within a few years.
I'm one of those I'm one of the few professors probably in the country that's actually taught cost of service rate making, because I'm that old now. And so I think, Hal's right with the battles of TELRIC, and whether, in terms of barriers to entry, just setting that marginal cost right. And even before TELRIC, there was avoided costs in the Public Utility Regulatory Policies Act, right? And all these other attempts to sort of ascertain what marginal cost is. And DOJ lost a predatory pricing case where marginal cost was one of those issues that was hard to figure out. And so I'm sitting here going, in terms of just to kick that to the curb and just to not let it get defined in any significant way, will lead to lots more litigation, I would think.
Mm-hmm.
It's a very complex remedy that's swept in like something like, oh yeah, just marginal cost.
Yeah. Well, I think this also ties into DOJ's, forward-looking proposal that there is this contingent divestiture of Android, which, Colorado AG Jonathan Sallet, sort of repeated over and over again, is that, having this sort of Damocles holding over Google does kind of counteract this temptation to cheat on and circumvent the other remedies, because Google knows that if those other remedies don't work, if it cheats on these other things, the DOJ can come back and say, well, look, competition, Google has circumvented the remedies. That's one independent basis, or competition has not been restored. And then the DOJ can come back and say, okay, well, all these other things didn't work, or Google circumvented them, so we should be selling off Android. And so that does create, knowing that that is an option, could be something that incentivizes Google to behave better than it would without that contingent Android divestiture hanging over its head.
All right, well, I think I'm going to take us then to the last question, if that's okay, Laurel. And it's this one, and I guess I'm channeling my inner Matt Stoller here, but if you could have held the pen, what additional provisions would you have put into the remedy proposal to try to combat this notion that the DOJ is being too timid? And I did have two candidates for you to consider too, because I don't think I see them in here. One would be on this question about whether or not DOJ went far enough to protect publishers in their dealings with Google over the terms of access to publisher content, including content used to train Google's AI. I don't know if you found that in there. I couldn't find it. And then the other one is, did the DOJ go far enough to prevent Google from preferencing its own AI product in search? So those are just my two candidates. But do you have any? I don't know. What do you think about those? And can you top those? I dare you.
Well, on the publisher content, there is something that, so publishers have this sort of, really bad choice where it's not a choice, that if they want to be ranked by Google search, they may have to allow Google to train on their content. And I think there is a proposal around allowing some kind of opt-out, and I don't remember the exact parameters of that. So there's something there, but, there may be other, opportunities to, again, thinking about the fact that there is also the ad tech case that is out there. Like, maybe there's an opportunity to look at the DOJ's initial proposal in that case and see if there's any kind of overlap where it would make sense to have something here that would work, because there is this ad market aspect to, very small ad market aspect to text ads in this Google case here. But in terms of remedies that, I would like to see, I think it was disappointing to see the rollback of this ex-ante structural relief about forward-looking, investments and acquisitions that Google can make in the AI space. And I would have liked to have seen that stay in, because I think there's a lot of, risk that Google is going to, sort of abuse that, or, use that as an opportunity to try to get, a political bribery settlement sort of thing. And I kind of wish that there had been a preliminary injunction early in the case, as soon as the liability phase was over, to immediately file for a preliminary injunction, because Google, during the pendency of the remedies phase, Google did go out and make, all kinds of brazen deals, right? So it continued to go and make a $1 billion investment in Anthropic. And, it continued to impose some of the same exclusionary terms, or tried to in some contracts about Gemini. So there's a whole bunch of different behavior that Google continued to try to do. And I think it would have been better to have a preliminary injunction to make clear, okay, there are a few things that Google just has to stop immediately. And I think that should have included certain types of AI acquisitions and investments. And, I don't know specifically if Google's attempted acquisition of Wiz for $32 billion had an AI angle or not, or a nexus to search. But I think Google would have, and I think that's one of Google's largest ever attempted acquisitions. I think Google may not have attempted that if it, we're under a significant preliminary injunction. And that deal is now, I think, being investigated or challenged by the DOJ. But, that's sort of wasted resources that we wouldn't have had to go through if that had been, part of the original. So, I don't know about, to what extent there's a nexus between Wiz specifically, but certainly that $1 billion investment in Anthropic would have been something. And I think, another thing that the judge is going to have to think about is what happens during appeal, because Google is going to immediately seek a stay of any remedies that are imposed. And the judge is going to have to decide which remedies go into effect immediately and which ones will be stayed. And that is going to have a huge impact on this inflection point around AI in particular. So not staying those remedies is really important. And Another area where I would like to see more in these types of cases is some kind of executive accountability. There is precedent out there, like in the Martin Shkreli case, where he was banned from life from the pharmaceutical industry for being a monopolist. That was a Section 1, Section 2 case, maybe some other causes, but that was something where, you know, he personally was held accountable, and that's something that, you know, is significant for deterrence. That executives are not just like, oh, well, I still personally made millions of dollars. I'm not having to give, there's no disgorgement from me. So, you know, maybe down the line, 10 years from now, my company will eventually have a consequence, but my career is going to be fine, right? So there's no disincentive. So I think that executive accountability should be a bigger factor in remedies. You know, which is another way, you know, not only as deterrence to others, but deterrence to that person to not repeat the same behavior. And I think that is especially appropriate in this case where there has been litigation misconduct, where lots of evidence was destroyed by Google's then general counsel, Kent Walker, but even, you know, high-level executives up to and including Sundar Pichai participated in this, you know, very shocking evidence destruction that has shocked 3 different federal judges and counting. And so it's very weird, both, you know, Google is now a triple monopolist and, you know, in all of those cases also shock the judges through evidence destruction, yet there is no personal accountability in any of those cases yet. The one that has come closest is that I think in the Texas ad tech case, where it's just the states, a collection of states having an ad tech case, they do have that case is a little bit farther behind in the proceedings. There is a motion for sanctions pending that does talk about Kent Walker specifically. So maybe that case will turn out differently. But, you know, I think that is something that judges should be thinking about a lot more seriously.
All right. Well, maybe the judge or their clerks are going to be watching or listening to this podcast, and you will have triggered some ideas. I think we might have to end it. Oh, one last question. I guess you did spare one, Laurel. Can the judge do anything that's outside of the bounds of what the DOJ has put forward?
Yeah,
You know that?
I mean,
Okay.
this is ultimately it's you know, remedies are an equitable matter, and judges can do things that are not just within the bounds of what the DOJ has asked for. So yes,
Right.
they have broad discretion. There is plenty of case law on that. One other point I want to make is that on this issue of Google's argument that because it's a monopoly maintenance case, the standard is different. Like, I do want to emphasize that apply textualism here, right? So it is creating a monopoly or maintaining a monopoly, you know, at the level of text, they're both offenses, right? Like, and Google is trying to impose this heightened standard that would essentially make it far more difficult to have any kind of remedies for monopoly maintenance. And, you know, there's nothing in text or legislative history that is like, oh, we don't think monopoly maintenance is as serious as an offense. No, it equally violates the law. So your task needs to be prying open the market and solving the problem.
I think we only use textualism or legislative history if it benefits the offenders. That's my understanding from Google and all those pro-competitive enforcement folks out there. So.
Well, Laurel, thanks so much for coming on to the show. I hope you had a good time, as good time as we did. And we look forward. We're excited to see how this trial wraps up and how the decision comes down.
Yep. Great speaking with you.
Okay, have fun. See you, Darren. Bye-bye.